Good morning, Your Honor. May it please the court, my name is Deanne Fields and I represent the Department of Children and Families. In this appeal, the order denying the department's motion to vacate arbitration. In this case, former DCF employee Melissa Ray was employed by DCF as an Economic Self-Sufficiency Specialist 1, or what we call an ESS 1 for short. Ms. Ray was a career service employee, and her position was listed in Appendix A of the master contract between the state of Florida and the American Federation of State, County, and Municipal Employees, or AFSCME. AFSCME represents the employees in the Human Services, Professional, Occupational Services, Administrative, and Clerical units. ESS 1 positions are covered by the master contract between AFSCME and the state of Florida.
Can we cut to the chase? And the thing
Sure.
I find interesting is it appears as though the party stipulated that the arbitrator was authorized to impose an appropriate remedy. How do we get around that?
That is actually a restatement of what's already in the master contract. What the master contract says is that in employment matters, the arbitrator determines whether or not the agency had cause to impose discipline on the employee. If there was no cause, then at that point, the arbitrator may fashion a remedy. The contract also says if the arbitrator finds that there was cause for discipline, then the arbitrator must uphold the discipline the agency imposed. And that is where we're running into an issue in this particular case. Because rather than—
let me jump in for a minute. I'm looking verbatim at the hearing transcript of the arbitration, and it says the following at page 156 of the record. The parties stipulated to the issues to be decided by the arbitrator, which is whether Melissa Ray was terminated for cause, and if not, what shall be the remedy? I mean, that just seems so cut and dried, because the arbitrator has whatever authority the parties decide to bestow upon the arbitrator. And the part at the very first thing that is said at the hearing is this is what we've all agreed to. And nobody jumps in and says, oh no, we haven't. I mean, it just, that's what's there in black and white in the transcript. And then again, at page 84 of the record, when the arbitration award is part of the record at page 84, the statement of the issue is basically the same, that the party stipulated the issue to be decided. And if she was not terminated for cause, what should be the remedy? So help me out.
Yes, absolutely. I'm looking directly at page 84, and it says whether Melissa Ray was terminated for cause. If not, and that's the operative phrase here, what shall be the remedy? The issue was that the arbitrator decided that there was cause to discipline Ms. Ray. If the arbitrator had decided there was no cause to discipline Ms. Ray, then at that point, the arbitrator will be able to fashion a remedy. Because it says, if not, what shall be the remedy?
Punish, but not cause to terminate.
Well, that's when we get back to the master contract.
I mean, didn't the arbitrator say that she did not find poor performance?
But why would the arbitrator impose discipline if there was no poor performance? The arbitrator stated that there were deficiencies that needed to be corrected. This contract between the Department of Children and Families as an agency of the state of Florida and AFSCME is not the same as a contract between the state of Florida and, let's say, the union that represents corrections officers, where arbitrators are allowed to determine if the discipline was appropriate. The contract between the state of Florida and AFSCME specifically precludes the arbitrator from determining whether or not the discipline was appropriate.
And if they had
that is the operative document that gives the arbitrator its authority.
Excuse me, if the parties hadn't stipulated to the contrary, I think you'd be absolutely right.
It is the department's position that the parties did not stipulate to the contrary because it followed the languages in the contract, which states, if not, what shall be the remedy? I believe that we have to give that phrase, if not its operative meaning. The arbitrator was only able to fashion a remedy if there was no cause for discipline. What the arbitrator attempted to do was to have it both ways. I'm going to find that there's cause for discipline, but I'm going to also find that there's no poor performance. If there's cause for discipline, which includes suspension or demotion, she suspended Ms. Ray for 30 days without pay, then what are you disciplining for if not a performance deficiency, if not poor performance? You don't get to discipline without Ms. Ray not fulfilling the terms of her employment. And that is the department's position in this particular case. Because the arbitrator decided to impose discipline, despite the arbitrator's statement that there was no poor performance, she's saying two opposing things at once. She can't impose discipline if there was nothing to discipline. If the arbitrator had decided that the department did not have cause to discipline Ms. Ray, then there would be no need for the arbitrator to then impose her own discipline. If Ms. Ray was employed as a corrections officer, the arbitrator will be able to decide, okay, there was cause for discipline, however, I disagree with the discipline imposed, therefore I'm going to substitute it with something else. The master contract in the instant case specifically precludes the arbitrator from making that type of decision. The arbitrator only has jurisdiction to affirm the agency's discipline. Furthermore, the master contract specifically states that no one, including the arbitrator, may modify or alter the terms of the master contract. So even if the court were to decide that we somehow stipulated to do something different, that was still outside of the arbitrator's jurisdiction according to the master contract. And you can actually find that section, let's see. Page 39 of the record limits the arbitrator's ability to fashion a remedy in employee disciplinary matters. And then under the contract, which you can find on page 41 of the record, the arbitrator must affirm the agency's disciplinary decision. And then it defines discipline as suspension, reduction in pay, involuntary transfer, or termination. And then further on in that same section, the contract plainly states that the arbitrator shall not have the power to add to, subtract from, modify, or alter the terms of the contract. I believe in this instant case, the arbitrator attempted to fashion her own remedy and to treat Ms. Ray as if she were a class of employee that was not covered by the contract that gave the arbitrator her jurisdiction in this particular case. This is not an issue of the arbitrator misinterpreting a contract. This is an issue of the arbitrator going outside the contract and going outside of her jurisdiction. Her jurisdiction is limited by the contract.
So is your position is the words, what the remedy shall be, means under the contractual framework, what it shall be, not something that she would fashion?
Correct, Your Honor. And it is my position that if not, what the remedy shall be is only applicable to the arbitrator deciding that we did not have cause of discipline.
Yeah, I understand that. I understand your argument is that first and foremost, that they don't have the authority to do that if there was cause, but then you're saying under the second provision, it wasn't a stipulation per se that, yeah, we're going to give you carte blanche to make whatever decision you want. It was the remedy under the agreement. That's your position?
Yes, Your Honor. It is also the department's position that it's settled law that the arbitrator's award settling a dispute must draw its essence from the contract and cannot reflect the arbitrator's notions of justice. And that is what the arbitrator attempted to do in this case. The arbitrator disagreed with the discipline due to the length of the employee's employment history. However, she does not have anything to draw from the contract that gives her that authority. And the arbitrator gave a plain restatement of what our stipulation was. However, she went beyond that, and she went beyond the four corners of the contract when she substituted her judgment for the department's judgment in imposing discipline. The arbitrator also stated in her award letter, it specifically talks about how she's not allowed to substitute her judgment for the department's judgment. And then the arbitrator understands that she is limited by the contract, but the arbitrator also, that's why the arbitrator decided to say that there was not cause for performance, because the arbitrator knew that she could not impose her own discipline if she found that Ms. Ray was a poor performer. So instead, she attempted to kind of split things down the middle and say, well, I'm not going to find that she's a poor performer because then that means I can't impose my own discipline. Instead, I'm going to find that there are deficiencies that needed to be corrected, and I'm going to impose discipline. The arbitrator has no authority to impose any discipline whatsoever. The fact that the arbitrator chose to impose discipline, and throughout the arbitration award, she pointed out Ms. Ray's employment deficiencies, means that the arbitrator understood that there was poor performance and that there was cause to terminate. There was cause to discipline because she disciplined herself. However, she cannot do that. She cannot go outside the four corners of the contract, and she cannot attempt to fashion a remedy that she saw fit to correct these deficiencies. She could either find that there were no deficiencies to correct, or she could affirm the agency's disciplinary decision. She could not do both. The department's going to reserve the remaining of its argument for rebuttal.
Very well, thank you, Ms. Fields. We'll give you, you have 5 minutes on rebuttal, okay?
Thank you.
Great. Ms. Rend?
Yes, thank you. May it please the court. Asnat Rend on behalf of the appellee, AFSCME, Florida Council 79. As your courts have, as the judges have noted during the oral argument, the union's first argument in support of confirming this award and not vacating it was based on the stipulation that the parties entered into the record at the beginning of the arbitration hearing. Now, I understand DCF's argument that the stipulation meant nothing more than what was already contained in the contract, was not meant to modify it at all. The problem with DCF's argument in that regard is neither the arbitrator nor the lower court found that to be the case. It is apparent that the arbitrator and the lower court relied on that stipulation in determining that the arbitrator in this case could in fact not just determine whether the employee was guilty of the offense for which she was charged, but also could determine whether the level of discipline was correct. That stipulation that was entered into by the parties is quite typical in the just cause analysis. In fact, a similar stipulation was entered into in the McDonald versus Hardy County School Board case that was cited to you out of the 2nd District. And in that case, the court noted that by entering into that stipulation, the parties had agreed that the arbitrator could determine the level of discipline. In this appeal, the standard of review is, of course, de novo with regard to whether the arbitrator exceeds his or her jurisdiction. But the findings of fact of the lower court are reviewed for competent substantial evidence. So while DCF may have a legitimate argument that it meant nothing more than what is already in the contract, the lower court had competent substantial evidence to determine otherwise. It could, just like the arbitrator, review that stipulation and determine that she had the power to amend the level of discipline. And in that regard, I cited to you Leneve, and I hope I pronounced that correctly, versus Via South Florida LLC, the case that clearly states that in the course of an arbitration hearing, the jurisdiction of an arbitrator can be modified by waiver, failure to object, and consent. And because of that, because of the stipulation, because there was competent substantial evidence to support the lower court's determination of what that stipulation meant, and because the jurisdiction of an arbitrator can be amended in that way through failure to object or through consent, on that argument alone, the lower court properly refused to vacate the arbitration award. As a secondary argument, I just want to make this point. DCF is making the argument here that because a 30-day suspension was issued, ipso facto, there was a finding that the employee engaged in the kind of misconduct that's delineated under 110.227 as justifying discipline. The problem with that and the fallacy of that argument, I think, is twofold. First, it ignores the stipulation entered into by the parties. I mean, the arbitrator was, again, operating under the understanding that she had this authority. And second, I think it ignores the very plain language of this award. And I think maybe you can look at it this way. Assume for the sake of argument that the parties had not entered into any stipulation at all. The arbitrator would have been presented with a case asking her to determine whether the employee was guilty of the misconduct for which she was accused, which was poor performance. I don't think there can be any dispute that in this award, the arbitrator found that she did not engage in poor performance. And having done that under the language of the contract, yes?
You agree that cause was found?
I agree that the arbitrator found that she was not guilty of poor performance. Having found her not guilty of poor performance, there was no cause for discipline. And under the language of the contract,
yet she disciplined her.
Correct. One, because of the stipulation entered into the contract, right?
I'll come back to that in a minute because I have a question, and that's something I'm struggling with. I don't know about my colleagues, but I want to follow up on that.
Right.
So your thought first.
Yes, I guess what I'm saying is that having found her not guilty of poor performance, then under the contract, if her choice is issue a discipline or reverse it and reinstate, her error was not in the failure. Her error was in the issuance of the 30-day suspension. In other words, it's not clear why, under the circumstances of this case, where an arbitrator found her not guilty of the offense of poor performance, that DCF gets to say, well, the only thing the arbitrator could have done was terminate her. I think the reverse is equally true, or even more true. Having found her not guilty of poor performance, the arbitrator, under the language of the contract, was obligated to reverse the discipline.
You could say that looks like cause. She found, okay, something is required here. And then you go back to the contract that says she doesn't get to fashion the remedy. So what you're really hanging on is the stipulation. You're saying, okay, well, she found cause, which the state's argument is, if you find cause, you don't get to decide whether termination's right or it should be something else. You don't even get to the stipulated part, which is what shall the remedy be. So that's I'm struggling with how that's not cause. If she said, "Yep, I just don't think termination. I don't feel like that's fair to the person." But that's not what we're dealing with here. If the department made a decision on what a remedy should be, and she found cause, do you agree that
I agree that if she
fashion absent the stipulation?
I agree that if she had found cause by finding the employee guilty under 110.227, the contract provides that an employee can only be terminated or suspended for an offense that's delineated in 110.227. One of those is poor performance. Having some work deficiencies is not listed anywhere in that statute. And what I'm saying to you is that if the arbitrator had found her guilty of poor performance, I think, and no stipulation had been entered into, I agree completely that the termination would have to be upheld. The problem
Okay,
in this
so
case,
you're hanging it entirely on the stipulation.
I think that the stipulation precludes a finding that the arbitrator found cause justifying the discipline.
Okay, all right, let's go to the stipulation, because I read this
Yeah.
carefully a number of times and I was going through it. So originally, at the beginning of the arbitration, the words were used, whether Melissa Ray was terminated for cause, if not, what shall be the remedy? So those words are, you can look at it one direction and go, oh, okay, she's going to decide what shall be the remedy, or from the other direction, what shall be the remedy based on the contract and what's controlling it. But then when she issues her order, she uses the words that the undersigned shall determine the remedy. So it's clear what she was thinking, but an acceptable understanding of those words could also be that they thought it was going to be what shall be the remedy based on the contract. So just like we are bound by what the remedies are based on what the statutes would require, we can't have parties, as a judge, can't have parties say, okay, well, we're going to agree whatever you think the remedy shall be. So I'm not convinced that there is this solid stipulation, or that even a stipulation could be entered that obviates the contract for under the state of Florida. So tell me why on any given day, someone from an agency of the state of Florida can go in and say, we understand the governor signed this agreement. We understand that there's all of these things that have taken place, but we're going to throw that all out the window. And you, Mr. or Miss Arbitrator, are going to be the person who's going to decide what an appropriate remedy is.
So, Your Honor, I think I saw that's what I referred to when I cited Leneve versus Via South Florida LLC. That case specifically says, and I quote, unlike the court subject matter jurisdiction, which cannot be conferred by the parties, an arbitrator's jurisdiction derives from the parties' agreement and can broaden during the course of arbitration by waiver, failure to object, and consent. Any contract, regardless of whether it has language in it that specifically states that an arbitrator cannot amend a contract. An arbitrator can never amend a contract, regardless of that language. But this concept that waiver and failure to object and consent can broaden the scope of an arbitrator's jurisdiction is something that is well established. And while, again, I agree that one interpretation of the stipulation could be that it is nothing more than what is already provided in the contract, the standard of review here on that finding of whether it is consistent with what is in the contract or has broadened the arbitrator's scope so that she may fashion the appropriate remedy is a question of fact that the lower court determined based on competent substantial evidence, because that same stipulation using that language has been interpreted by many courts, including this court, as permitting an arbitrator to determine the level of discipline.
You're saying that because the lower court judge construed it to mean that the arbitrator had the authority to determine the punishment, that the record does have competent substantial evidence supporting what the trial judge did, and we therefore should uphold.
Yes, yes, the stipulation is included in the record, in the transcript.
Because the lower court order was highly deferential to what was determined at the arbitration.
Yes, I believe the lower court order referenced, or actually said, that by entering into that stipulation,
You did say
the
it
parties
did
agreed.
reference the stipulation, I remember.
Yes.
Can you give me the
Correct.
site
And that's
of
the
that?
same way that's the same way the arbitrator interpreted the stipulation.
Give me the citation of that case you were reading from a minute ago, if you would.
It is 908 Southern 2nd 530, and the portion I read is at page 535. 534, 535.
So in other words, in order to reverse the lower court judge, we would have to find that there is no competent substantial evidence that the arbitrator had this authority.
Correct.
which is not what he found the opposite.
Correct. Correct.
Okay.
Mr. Ring, can I take you down a different track? The only basis for the proposed discipline was poor performance.
Correct.
I am wondering, one could have some job deficiencies that would not rise to the level of poor performance.
Exactly. Correct.
So
Correct.
maybe the arbitrator is saying, you know, you're not quite an A student, but if you do a couple extra things, I'm going to get you from a B to an A.
Exactly. And I think really the notion of due process would preclude, you know, having the arbitrator, well, said a different way. Yes, I cited case law in my brief that said that when an employer and DCF accuses an employee of a particular misconduct, it is their burden to prove that that misconduct occurred. They did not prove that. I think she said repeatedly, and I heard Ms. Fields say today, well, she must have found poor performance because she issued the 30.
You just went mute. You just went mute, Ms. Wren.
Oh, the host had muted me. I apologize.
There we are. You just went mute again.
I'm getting messages that the host is muting me. Okay.
All right. You
In
look-
any event,
looks
I've
okay
lost.
now.
Okay. I lost my train of thought a little bit there, but yes, I mean, they have the obligation to prove that. And again, this award is extremely clear that the arbitrator found that DCF had not proved what was the burden in their case, which was that she was a poor performer. Correct, 100%. And like I said, absent the stipulation, the conclusion there would not be that you have to uphold the termination. Absent the stipulation, it's the union's position that the only thing the arbitrator could have done at that point was reverse the termination. And that's why I've argued here that the error, if any, is not in the issuance of the 30-day, is not in the failure to uphold the termination. It's in the imposition of the 30-day suspension. The union is not arguing that here because the union accepts that they entered into a stipulation that allowed her to do that. And with that, I would ask you to uphold the lower court's decision. Thank you.
Thank you, Ms. Ring. Ms. Fields, 5 minutes of rebuttal.
Yes, a few points, Your Honor. The first point is regarding the arbitrator's ability or even the agency's ability to impose discipline on an employee. Section 110.227 Florida statute states that discipline may only be imposed for cause. Discipline may include suspension, demotion, or dismissal. Suspension is a form of discipline that can only be determined for cause. Once the arbitrator determined that the employee should be suspended, then she believed that there was for a cause, or else the arbitrator herself is going outside of 110.227 when she imposed the suspension. The other issue is that the lower court did not address the arbitrator's limited authority under the contract. The lower court decided that we somehow stipulated to something when it is clear there was no meeting of the minds on what the stipulation actually was. The department's written arguments in the arbitration made it clear that we were only stipulating to the arbitrator having the authority to determine a remedy if there was no cause to discipline the employee. If there's cause to discipline, then the arbitrator must uphold the agency's decision on discipline. The arbitrator clearly found that there was cause to discipline because she imposed it herself. Now, if the arbitrator thought that Ms. Ray's deficiencies did not rise to the level of poor performance, then what the arbitrator had the authority to do then is say, department, you shall reinstate Ms. Ray. The department, you shall give Ms. Ray X amount of dollars in back pay. But she did not have the authority to then go in and impose her own discipline. Imposing her own discipline, according to 110.227, means that the arbitrator agreed that there was cause, or else the arbitrator is going outside the statute.
Ms. Fields, under that argument, DCF would be worse off because you'd have to pay her back, back pay, whatever benefits accrued, at least this time. All right, you can't terminate her, but we're going to give her a warning of the 30-day suspension. I mean, would you rather have that, or would you rather have her reinstated and have to pay her all your back pay?
Your Honor, I would rather the contract be followed according to what was written in the contract. And the department understands that if we lose on proving whether or not someone's a poor performer, then we have to take that person back under whatever remedy the arbitrator fashions. However, if we do make our case that we had cause to discipline that employee, then whatever disciplinary method we choose must be accepted by the arbitrator, because that is what we agreed to with the union.
Counsel, let me ask you one last thing. The order by the lower court, in fact, construes the arbitrator's authority different than what you're arguing today. In other words, the lower court determined that the arbitrator did in fact have the authority to issue the 30-day. Given that we're reviewing that order for whether or not it's supported by competent substantial evidence, should that not be an affirmance?
The lower court did not
In other
have.
words, the lower court record does support one interpretation of the arbitrator's authority.
Your Honor, I would
To the
disagree.
complete exclusion of the other possible interpretation. If I give you the benefit of the doubt that the other one is a possible interpretation, we're reviewing to see why the trial court decided what it did, and the trial court does lay out the reasons for its decision. So how are we not to affirm that holding?
Because the trial court goes outside the contract, which was supposed to be the governing document.
The issue is whether the ruling is supported by competent substantial evidence.
It is the department's position that it is not supported by substantial competent evidence, because the arbitrator did not have the jurisdiction to make the decision that she made. And that is what the trial court was limited to. What is the arbitrator's jurisdiction under the contract? The arbitrator's jurisdiction under the contract was either to find cause and affirm the agency's decision, or not find cause and to fashion a remedy. There's no competent substantial evidence that the department, that is even a reasonable interpretation that the department intended to alter an agreement signed by the governor. And we believe that there was no competent substantial evidence for the trial court to make such a finding.
Judge LaRose, you're muted.
Ms. Fields, you're going to have to wrap it up, please.
Okay, in conclusion, the department did not agree to in any way to alter the terms of the agreement. Even the plain language of the arbitration award does not state that the department in any way intended to alter the terms of the agreement. It's simply a restatement of what's already in the contract. So I do not believe that even using the arbitrator's award letter, that there is justification to find that we made such an alteration, because the arbitrator herself does not even address that.
Very well. Thank you very much, Ms. Fields. Thank you both. That concludes our docket for this morning. The court is adjourned.